Generally, under the doctrine of joint and several liability, when two or more defendants commit a tortious act and cause the plaintiff to suffer a single indivisible harm, the defendants may be individually or collectively liable for the harm. But what if a defendant contributes to the harm but doesn't physically cause it? Will that defendant still be individually liable for causing the harm? The New York Court of Appeals considered this question in Carvalho v. Brunner. On April 25, 1911, Oscar Brunner was driving a one-horse truck that he owned north on Water Street in New York City. At the same time, another person was driving a two-horse truck that was owned by E.J. Johnson and Company in the same direction on the same street. Eventually, the drivers met up and began to race side by side. According to witnesses, they were going as fast as an ambulance or fire engine responding to an emergency call. At the time, a New York City ordinance prohibited persons from driving at a speed greater than what was reasonable, or at a rate that would put people at risk of death or bodily injury. When the drivers were about 15 feet north of the intersection of Water Street and Wall Street, Brunner's one-horse truck struck Anna Veriroli de Carvalho, who was crossing the street. As a result of the collision, Carvalho died. Subsequently, de Carvalho's estate sued Brunner and Johnson in New York Supreme Court. Following trial, the jury returned a verdict against Brunner and Johnson for $10,000. Johnson appealed to the appellate division, which reversed, concluding that Johnson wasn't the cause of de Carvalho's death and therefore wasn't liable. Consequently, the court dismissed the complaint against Johnson. De Carvalho's estate appealed to the New York Court of Appeals.